Hello and welcome. Thank you for joining us today. Please take a moment to introduce yourself, your farm, or your organization, and your location in the chat. We are grateful to the Transition to Organic Partnership Program, or the TOP program in the Plains region, for supporting the work that went into this webinar. We will use the Q&A function for questions or the chat, whichever works for you. And please feel free to pose those at any time or to raise your hand and come off mute and pose a question. Rachel's very comfortable taking questions throughout. It is my pleasure to introduce our presenter. As the founder and executive director of Farm Commons, Rachel Armstrong creates the organization's innovative approach to farm law education and risk reduction. Ms. Armstrong instructs continuing legal education classes for the American Bar Association, teaches farm law for the University of Massachusetts Amherst, and is a co-author of Farmer's Guide to Business Structures, published by Sustainable Agriculture Research and Education. A graduate of the University of Denver Sturm College of Law and the University of Wisconsin-Madison, she lives in northern Minnesota with her husband and 3 children. Today, Rachel will share with us how to protect our farms from buyer bankruptcy. Over to you.
All right. Well, hello, folks. It is great to visit with you today. Okay, my slides should have popped up in front of you so you can follow along. So indeed, we're talking about protecting your farm from buyer bankruptcy. Credit to Harriet Behar of Organic Farmers Association as well. She developed this, this original presentation with me and helped me out in understanding a lot of what farmers are experiencing and then how the law corresponds back to that. We got a little logo here for you at the top of the program, just to make sure you understand where we are coming from here. So if you haven't heard of Farm Commons, I'll tell you a little bit about us. Our mission as a nonprofit charitable organization is to empower agricultural communities to address their own legal vulnerabilities within an ecosystem of support. So we do exactly this. We do a lot of webinars. We also write guides, host workshops, do podcasts, run a question and answer platform. I am an attorney. We're staffed by attorneys and folks with education expertise so that we can create material that really speaks to farmers' concerns. We also believe that farmers are the best source for solutions to their own problems. And so we emphasize leadership development and helping farm communities understand how to move forward. We're a membership-based organization. And I bring that up because I want you to know that we don't do this to earn legal services clients. You can't really go out and hire us, and be like, Rachel, love the presentation. Now can I pay you to revise my sales contracts? Not really. No, we write grants and and do those methods of funding our work. And I bring that up to make sure you know that we strive to provide you with really accurate information about how the law works, when an attorney can help you out, and honestly, when you can do something yourself, for example. Okay. So keep those questions coming. I do love to hear what you are thinking as we go along, and I'll have my eye on the chat box as we proceed. A little bit more about myself. I'm joining you from Duluth, Minnesota. This is where I grew up. This is where 6 generations of people before me have lived. A picture of the actual ancestors there doing their farming of cabbage and potatoes back when land was cut over, harvested for pine, and turned into farms. Okay, so let's get going on our subject matter today. So, this is a little bit obvious, but I'm going to talk to you first about sales channels, ways that grain farmers might be moving their product. Of course, you could sell it direct to another farmer. That happens. Some farmers sell their product through cooperatives. But honestly, what a lot of producers do is they sell to a processor or to a broker. I want to draw a distinction between these couple of different sales categories here. So our top 2, the ones that are not in bold, selling direct to another farmer or through a cooperative. These tend to be smaller scale transactions. They're transactions where farmers have more power. They have more input into things like the delivery dates, the payment schedules, maybe even the prices that they receive. So they have a lot of potential to control the transaction, a lot of visibility into what's happening, what's the buyer doing with that product, what are their interests, even issues like, well, how much debt does that buyer carry, what sort of market influence do they have. There's just a lot more that can be known about those transactions. But they're often smaller, and many times our farmers need people will buy a lot of product. Like a lot of acres. They need to move more. So when we're talking about a larger scale, we're often our buyers in bold, processors and brokers. But what comes with that scale is more exactitude in the buying relationship. These contracts, and there often are sales contracts that go with them, they are more precise. There are narrower quality standards. And if the product falls outside the quality standard, there's fees and things like that. There are precise delivery schedules, systems of payment, and these usually come from the top. The processor and the buyer and the broker, they're the ones who are saying, this is how we buy. And it's often a take it or leave it kind of scenario. There's not as much of that visibility, not as much as that opportunity to create a relationship that works more for the farmer. What comes with that is often more vulnerability. And today we're talking about the vulnerability that a farmer experiences when that buyer goes bankrupt. With the processors and the brokers, we usually have a larger number of farms that are affected when those folks go bankrupt. Because again, they're operating at scale, they've purchased from a huge variety of people, and the volume of the sales is usually larger. Being national or even international corporations, maybe moving huge volumes of product. And so a farmer might sell their entire season's harvest or the wide majority of it to that one buyer. What comes with this is lesser opportunity for the farmer to protect themselves with the contract. When the buyer puts a contract on the table and is like, take it or leave it. If you don't want to sell to me, I'll go find somebody else who will. And they're right about that. Somebody else will probably sell to them. So it doesn't put the farmer in a good bargaining position about how that sale is going to proceed. The fourth thing to note about selling to processors and brokers is that these being very large national or multinational corporations, they may be operating with more debt, with investors, and with other big money mechanisms. What I'm trying to say is they got secured creditors. They have people who have given them money under the promise that they're going to get paid back first if it all goes bad. So what that means is that farmers get bumped down in terms of their security when we're dealing with these larger entities with investors and other debt mechanisms that are funding their operations at scale. But that being said, all is not lost. Farmers have power, even in these sales relationships with large corporations, with our brokers and our processors. There are steps that farmers can take to protect themselves from buyer bankruptcy. And there are things that producers can do to minimize the impact if it does happen. Because as we all know, it does happen. Probably fresh in your mind, experiences like a pipeline bankruptcy and others that had a widespread impact on producers and caused a lot of bad things to happen, and certainly an enormous amount of stress and distress as farmers figured out what this meant for them and how to minimize that impact. So today, our emphasis is going to be on proactive. What can we do now to minimize future impact down the road if a buyer goes bankrupt? There are some things that you can't do. And we're gonna not emphasize those things because you can't do them. We're gonna focus on what you can do and where, no matter who you're selling to, you still have power. So before we get to those action steps, I want to talk about our the overarching system that we're operating in. So let's talk about bankruptcy itself. Bankruptcy is a process that is overseen by the courts. It is designed to achieve a fair resolution for everyone concerned when a business becomes insolvent. So I gave you one sentence, I paused a lot because it's kind of loaded. There's a lot going on in there. First, I want to emphasize a process overseen by the courts. I mean, that's what's supposed to make this fair, right? What way back when bankruptcy was invented, what the United States of America didn't want is companies just going out of business left and right and just craziness happening. Like that's bad for commerce, right? If you have no idea what's going to happen or if anything's going to be fair, if this business goes out of business, then that limits people's willingness to buy and sell amongst each other. So the court stepped in and said, look, don't worry, don't worry. The system is controlled. Somebody will step in who is objective and fair-minded to oversee this process. The other thing to note is that this is supposed to be fair for everyone concerned. I don't know if you all are Calvin and Hobbes fans, but I sure was as a kid. And one of my favorite comic strips was the one of Calvin and Hobbes with these little angry clouds over their heads, saying that a good compromise is one that leaves everybody mad. And often that's the case. And I tell my children that today as they're trying to achieve compromise. If everybody's mad, maybe we did something right because everybody lost a little bit of something. And that is very often what fairness looks like. The law isn't trying to punish everybody. It's just often what fairness means, is that everybody has to suffer. So that's the general principle behind the bankruptcy process. And within that, we have specifics. We have different chapters of bankruptcy. And chapter refers to the part of the legal code that describes how that bankruptcy is going to proceed. When we're talking about buyers, grain buyers, we're normally, or really, well, not any other buyer. I do want to say that much of our conversation today is about grains. If what you move is fruits and vegetables, the situation is a little different. Not a lot, but is a little different. So our emphasis today is on grains. And in a grain context, we're normally talking about two chapters that are options for a buyer bankruptcy, Chapter 7 and Chapter 11. Just by way of reference, most family farms that are going to go bankrupt are going to use Chapter 12. So again, what I'm talking about today is not necessarily relevant if we're talking about a farm bankruptcy. We're talking about buyer bankruptcies, emphasis on grain, Chapter 7 and Chapter 11. I'm going to give you a one-sentence explanation of how Chapter 7 and Chapter 11 work. In Chapter 7, the trustee manages a liquidation process for the benefit of all the creditors and the public at large. Keyword, liquidation. This is your classic going out of business, sale, everything must go, all the assets converted into cash, cash spread out amongst the creditors who need to get paid back. Chapter 11 is a little different. In Chapter 11, the trustee works to restructure the debt so that the business can continue operating, so that they can continue to pay down the debt that is reasonable for that business. This is not a fire sale. This is not everything must go, convert to cash, go out of business. This is, look, we have way too much debt for the size of our enterprise and for our, sales and revenue, but we still have a good business model. We're still able to make some money and produce some profit, just not that much. So what Chapter 11 is trying to do is to create a business that's still workable while getting rid of some debt. And that's really a key distinction I want to make for something I'm going to talk about later. But Chapter 11 is trying to keep the business in operation. Okay, so there was another key word that I said that I want to explain. Trustees. Trustees manage this process. The business itself doesn't manage the process of liquidation. Trustees manage it. And they are usually attorneys who sit in law firms who specialize in working things through bankruptcy. And they are supposed to be removed from the situation. They're objective. They've seen and done this 100 times before. They know how the process goes, and they have a public duty to see that the process follows the statutes. So that's the overview of how bankruptcy works. And now I'm going to dive into a couple of core principles and what they mean for farmers that are selling to an entity that should go bankrupt. So core principle number one, a business shouldn't be able to pick and choose who gets paid and who doesn't. And I'm not saying that's my core principle. I mean, maybe it is, maybe it isn't. But what matters here is that this is the statutory principle. This is what the law says is a principle. A business should not say, I mean, times are hard. I'm going to go out of business, but you, Uncle Joe, you get paid. And you, Aunt Sally, you didn't give me a very good birthday present last year. I'm kind of mad at you. You don't get paid. That's not fair. The principle is that similar creditors should be treated similarly, no matter what sorts of relationships or favors or, other angles we might be trying to work as we are in the process of shutting down this business or reorganizing. So if similar creditors should be treated similarly, this leads us to another thing that happens. And that thing is called clawback. Clawback sounds horrible. It is horrible. Here's what it is. After a buyer files for bankruptcy, we go through a process of recovering all payments made by that buyer to suppliers in the 90 days prior to them filing bankruptcy. The idea here is let me show you one of these letters. We're going to go right to it. Okay. It's pretty horrible. It is a letter that goes, in this case, to the farmer. This is the pipeline case. A letter sent to the farmer who sold grain to pipeline. And it comes from the trustee, and it demands the return of money. So this is an example here. It says, this letter right here, our firm represents Nani Manti, the court-appointed liquidating trustee of the bankruptcy estate of Pipeline LLC. Blah, blah, blah. Pipeline filed bankruptcy on July 8, 2021. Our records show that you sold product to Pipeline and that Pipeline paid you $261,000 in rough change. Now skip that down to that bold. Therefore, your company must return $63,000 within 21 days of the date of this letter. Make the check to Nani Manti, trustee. If payment is not received within 21 days, we will be forced to take further action against you and will commence litigation. So yeah, pretty horribly terrifying to receive one of these letters. They are literally saying, give us back the money we paid you for the product that we bought from you. And this isn't going to make it feel better, but let's talk about why. Why are you getting that letter? Because the trustees need to claw back all payments that Pipeline Foods made in the 90 days before they filed for bankruptcy so that they can be redistributed and redistributed fairly. The assumption in here is that every payment that Pipeline Foods made before it filed for bankruptcy was preferential. They knew the business was or would shortly be insolvent. They had to have known that they were going to file for bankruptcy. And we know that because they're shopping around for who's going to represent them and how this is going to happen. So they know Pipeline Foods or whoever the buyer is knows that this is going to happen 90 days before. And they're out there being like, okay, there's only so much money to go around. Who are we going to pay? They're picking and choosing who gets paid. That's the assumption. Are they or aren't they? We don't know, but the court is going to assume that those payments were preferential and it's going to ask for them all back so that the court can reconsider who does and does not get paid. So again, it's a terrible letter to receive. They don't try to make this kind. They don't try to explain why this is happening. They show zero understanding of the farmer's financial situation, as if you just have $63,000 still sitting in your bank account, as if you don't also have bills to pay and people who need that money. None of that is part of it. It's just give us the money back. And if you don't, we will come after you. So they're not trying to be mean. They're trying to follow the processes of what is fair and what is not, and trying to make sure that everybody gets treated the same. But that's not your situation. As a farmer, you kind of need that money to keep paying your bills. So what can you do? There are things that you can do in response to a clawback letter, and let us work through those, okay? So here are some action steps that you want to keep in mind if you ever get one of these letters. Okay, the first thing you're going to try to do here is argue that the payment was not preferential. So basically what you're saying is, come on, I am not the favorite Uncle Bob. They didn't pay me because they like me. I mean, they paid me because my bill was due. My invoice was up. So more precisely, in the terms of the law, you're going to argue that your transaction occurred in the ordinary course of business. And sorry, if you notice my formatting got a little wonky here, I didn't have time to correct all these some weird fonts got in. I was trying to fix them. So ignore that. So you're going to argue that your transaction occurred in the ordinary course of business. And what does that mean? Ordinary. It means the same way we always done it. You are going to show that you sold them the same product last year at the same time. The form of the payment was the same. The timing of the payment was the same. The way you calculated the payment amount, price per bushel, whatever, it's the same. So you're going to have to pull all the records from, hopefully, your 5 or 10 years of history with this buyer, showing we always did it this way. They always paid me 30 days later. That's going to help show nothing out of the ordinary here. They didn't all of a sudden pay all my invoices in a rush because they liked me better. They did it because they always did it that way. So this can be a successful defense. Recall I said that the assumption was that all payments made 90 days before the bankruptcy filing were preferential. But you can defeat that assumption. You go in and say, okay, good, look, I get it, but not me. This one wasn't. And so you got to produce all these records to be able to show that. Now, that is really hard to do if you're a new customer. If this is a fresh buyer for you, you've never sold to them before, how do you show that this payment was made in the ordinary course of business? You don't have any ordinary. Oh, look, somebody asked that in the chat box. Beautiful. It's just a lot harder. Can you use someone else's normal to show ordinary course of business? Generally, no. Because the distinction is, or the assumption is, that they liked you more. And so we don't have that they treated someone else normally doesn't prove that they didn't like you more, than someone else. So so this is really a difficult situation for someone who's selling to a new buyer. And there isn't necessarily a good response to that. Like, well, if you're a new buyer, then do this. It's just harder to show ordinary course of business here. And this is a situation where farmers are just unique. I mean, bankruptcy is crafted for everybody in this context because this is not Chapter 12. This is crafted for all kinds of businesses that buy and sell, and these yearly singular annual sales of like $200,000, then nothing for another year, then $200,000, nothing for a year, is not as normal as, a purchase every month, or those sorts of things. So it's the unique nature of farming, the annual harvest, that makes the situation not quite work for farming, but it is still the situation we have. Okay, so what happens after the clawback process? If you can't make this argument, if you can't prove that it was in the ordinary course of business, you usually end up having to give the funds back, give your payments back. And then what's going to happen is the trustee is going to pull all that together. They're going to pay off the secured creditors first, and then they're going to pay off the unsecured creditors, which is what you are in this situation, equally. So this depends on how much debt the buyer is in and whether those creditors are secured or not. If every cent that the trustee takes in goes to pay off secured creditors, then the unsecured creditors, the farmers usually in this situation, end up with very little. They might get pennies on the dollar or very long repayment terms. They'll get paid a little bit a year for a long period of time, and still not recover everything. Okay, is someone in the chat box? We have a question. Can you have a statement on your invoice that this is in the ordinary course of business that is sent to the buyer? Well, my attorney answer is, you can do whatever you want, but that doesn't mean that the court will agree with you. So this is a situation where the court, you're still going to have to make that argument, and you're going to have to prove that it wasn't preferential. So, so let's say that you don't send the money back to Pipeline after you get that clawback letter. Instead, you engage with them on the merits and you say, no, I'm making an ordinary course of business defense. Here's my proof that this was in the ordinary course of business. Look here, I have an invoice that says ordinary course of business. The judge or the trustee is going to say, that's not enough. I mean, great. So you said it. Saying it doesn't make it so. Give us your records. Prove it was in the ordinary course of business. So it could be a piece of evidence where you say, well, okay, fine. I'm proving it with this statement. Look, the buyer agreed this was in the ordinary course of business. But that's easiest if you have some like actual assent. And payment of the invoice may not be enough to prove assent that they agreed it was in the ordinary course of business. Otherwise, you know how it is. Everybody would do it. And then the bankruptcy process wouldn't work. So this is one of those cases where it's like the system works as planned when everybody has to put the money back, and then everybody takes a haircut, takes a little bit of a loss on it. I'm not saying it works for you. I'm just saying that actually is the court's desired outcome in a lot of these instances. So I have more solutions to offer other than the ordinary course of business. But I am going to take a pause here in saying that this is one of the inherent risks of doing business. Whatever it is that you're selling to a buyer, this is one of the risks, that your buyer will go bankrupt. And if you got paid within the last 90 days, there's a problem. So we have other solutions. Let's go there. Let's look at some of our other solutions, because the bankruptcy process itself presents some barriers. Okay, so how can you be made whole here? Look, state governments have recognized this problem, and this goes way back. This isn't modern. This goes back to the founding of states, and some of the first statutes and laws that they passed was to recognize this problem, that farmers are vulnerable to their buyers. So Most states have some kind of protection program in place to try to address this. The first kind that you might find are state grain indemnity funds. 11 states have an indemnity fund. They are there specifically to help make farmers whole who do not get paid by their buyers. Now, these indemnity funds have various levels of health. Some of them may be anemic, wilting on the vine, in poor health, and others may be strong and may have, good backing and financial resources to make sure that in the event of a large-scale buyer bankruptcy, most farmers are going to be made whole. But a lot of other ones are kind of weak, and so maybe everybody still takes a haircut. They're only going to get 50% of what they, were owed. Still, many more states have a bonding program. Now, a bond program, to speak very generally, the difference between an indemnity fund and a bond program is generally that a bond program is funded by the buyers themselves. All the buyers have to put into this fund so that if any one of them goes bankrupt, there is a pool of money to make the farmers whole. Grain indemnity funds, by contrast, are usually not funded by buyers themselves, but also or exclusively by the state government that is going to fund it. So that means, of course, more resources. The states got more, because bonding programs work like a tax, on the buyers. So let's say that you're subject to a clawback. You give back your money and you only get 10 cents on the dollar. Then, and in addition, you go to your state and say, okay, now I'm going to make a claim with the indemnity fund to try to make back more of that 90 cents on the dollar that I just lost. Of course, if your buyer was large and every one of your peers also sold to them, they too are also going to the indemnity fund or the bond program, and everybody's getting a smaller piece of that pie. I've got another question here. Is there a way you can change from being an unsecured creditor to a secured creditor when selling grain? Love it. Coming up. You were thinking on the right path. Okay. But let's continue down this path of you got clawed back, and what can you do? So this is a situation where it is worthwhile to build relationships with your elected representatives in your state and your departments of agriculture. They have power. Buyers are licensed. 31 states have a licensing process for grain buyers that is there to control buyers and is there to create security for farmers. If that licensing process isn't good enough, that grain indemnity fund isn't strong enough, this is your voice to be heard. Tell your elected representatives that you don't like how that program is running, and you want to see some more security. Okay, now we're going to go on to this awesome question about how do you become a secured creditor. Okay, this is our most important proactive step that you can take right now to protect yourself from future buyer bankruptcies, and that is don't become an unsecured creditor. Don't become a creditor at all. How? Get paid when you deliver the grain. The essence of a creditor is you put in on the expectation of being paid later. That is what a creditor is. So you need to be paid when you deliver the product, not 30 days later. So, and you need that to be memorialized. Not only does it need to exist in fact, you are paid when you deliver the grain, but you need to memorialize that intention in your contract for payment. You need your contract for payment to state that this is a contemporaneous exchange and that there may be a small gap between delivery and payment. What's a small gap? It varies depending on what state you're in. But you got to think on a matter of hours and one day, not 10 days. So think of it like I'm shopping at Target. When I'm shopping at Target, I don't get to say, I'll pay you in an hour. I'll come back. I'll come back with a check. No, you pay before you walk out with the thing you bought at Target. That is a contemporaneous exchange. Boom, give, get. So you need to hew very closely to that. So here's why I did not bring this up as the very first thing you can do. Remember how I said at the beginning that you're working with a national or multinational corporation on a take it or leave it kind of contracting basis? They don't invite you in to be like, what works for you? When you want to get paid? They pay 30 days later. You extend them credit or they don't buy from you. Now, I say that in those absolutist terms because that's the way like the reality feels. Do you have power to change that? Well, the hope is maybe you do if you work together. I venture to guess one farmer standing on her or his own is not going to succeed in that. Do you have 1,000 farmers standing together saying this is the way it's going to be? Do you have elected representatives backing them up to say, yeah, this is the way it's going to be? Maybe you're going to get somewhere then. So that's why it's not my leading suggestion, because I live in the real world and I know that this isn't going to happen tomorrow. But I do want to put it out there as the single best proactive thing that could be done. Don't become a creditor. Okay. So let's assume that we need some runway. We need some time and some advocacy. And, let me slip in. I am here because of Organic Farmers Association, who like, look, that's why y'all are getting together as an association. So think of, who else you can leverage. But anyways, I got my other one. Let's talk about become a secured creditor. So, okay, fine, we got to be a creditor. Let's try to be a secured one, because secure creditors are first in line for payment under bankruptcy. Unsecured creditors are last. If you drop off 3 loads of grain and you say, pay me in 30 days, you're an unsecured creditor. But if you take some extra steps, you could become a secured creditor. This happens by filing an agricultural lien. Now, an agricultural lien, unfortunately, is mostly available in states that do not have indemnity or bond programs. And it's available in those states because they're not giving you anything. So they'll at least give you an agricultural lien. Now, usually what happens if you want to perfect your agricultural lien, what you're going to do is you're going to file with the Secretary of State's office a record of the sale that was made, and then your lien lasts longer, and for 90 days or something like that. And then if the buyer goes out of business, files for bankruptcy, you are still secured and you can get paid back first. Assuming, of course, that there are resources to pay off secured creditors. It does happen at some points that there isn't even enough money to pay off secured creditors. So I'm not going to say you're getting 100 cents on the dollar here, but you're in a much better position than your unsecured creditors. So if you file with the Secretary of State's office the record of that sale using their form with which to do that, you can get your lien to last longer. But again, the states that have indemnity or bond funds, and remember, 11 states have indemnity funds, 30 have bond funds, they don't usually allow you to file an agricultural lien. They want you to use the indemnity or bond fund, which, as you know, could be underfunded, and so still leave you lacking. Okay. Deep breath. We've covered a lot of good business. Some good news, some bad news. I got a few more slides to go. Keep those questions coming. I'm loving it. I'm going to make a transition to another issue. We're going to move away from the clawback issue and the fact that you sold them product and now they're taking their money back from you. And we're going to talk about something else. I have another core principle of the bankruptcy process. A business shouldn't be able to break valid contracts just because the buyer is reorganizing through bankruptcy. So I'm going to actually, the seller shouldn't be able to break valid contracts just because the buyer is reorganizing through bankruptcy. Make that a little bit more clear. Why, if we allowed sellers to break valid contracts that they have with the buyer, then the damage will worsen. Everybody will jump ship. If we feel like, oh my God, this boat sprung a leak, everybody bail, jump off board, then the ship will definitely go down. But if we say, okay, yes, the boat sprung a leak, this is not good, but we're going to plug it. We're going to plug it. We're going to scoop out the water and, don't jump overboard. We're going to save this thing. That's chapter 11 bankruptcy. We're going to save this thing. We're going to reorganize. There's hope. We're going to, offload the bad and we're going to keep the good. And in order to do that, we have to still have a viable market. We have to be able to buy and sell product. We have to be able to process the soybeans into tofu. We got to do the things because otherwise we really will go down. The ship will go down. So public policy here is, especially in a chapter 11 bankruptcy, you can't break valid contracts, even as the seller / vendor to the buyer. So this is not a pleasant place to be. Let's say well, I'm not pretending. This actually happens or happened. So people found out, okay, Pipeline Foods filed for bankruptcy. But if you had a valid contract saying you needed to deliver grain to them next week, you had to deliver grain to them next week. You weren't allowed just to say, oh my God, you're filing for bankruptcy. I'm not going to give you my grain. Accept. So that's the principle. In principle, you are not allowed to say, I'm not going to sell you my grain. You're going bankrupt. What you are allowed to do is to demand adequate assurance of the buyer's ability to pay. And if they do not give you adequate assurance, then you are allowed to refuse to deliver them some product. So let's say Pipeline Foods filed for bankruptcy 1 week ago. You're panicking. You got to bring them some grain next week. You need to reach out. You need to get a hold of Pipeline. And here's where it's very useful to have an attorney. You need to get a hold of Pipeline Foods and say, you give me adequate assurance that you are going to pay me 100 cents on the dollar for this product that I'm about to bring you next week. And if you hear nothing, you don't make the delivery. And if they write you back and they say, look, we have valid contracts to resell this product, or we are still making tofu, if they can assure you, and this again is where it's valuable to have an attorney to help you assess what is adequate assurance in this instance. But if they provide you with it, you do have to bring your grain. But again, assuming this is all on the up and up, that they will pay you for it. Yes, all of those payments made 90 days prior are getting clawbacked. But not all payments made 90 days after. Clawback doesn't apply to future payments. It applies to past payments because we already have the oversight of the court system. We have the oversight, and the court system is there to help make sure that this train stays on the tracks. Vendors will supply, the buyer will pay, will recover. It's hard to do on your own, though. Hard to get the attention, file all the processes, assess the adequate assurance. So it depends on what's on the line for you. And honestly, that's why the state of Minnesota in the pipeline case stepped in and said, look, you don't have to deliver. Because it was just easier for the state of Minnesota to say, look, everybody, you don't have to deliver, rather than every single farmer writing to demand adequate assurance. And Pipeline trying to assure every single one of these vendors, these sellers, that they could pay. Because honestly, maybe they couldn't pay all of them. They could pay some of them. Anyways. And the spoiler, you probably already know this, Pipeline filed for Chapter 11, but then they converted to Chapter 7. Like, it didn't actually work to keep the train on the tracks. And that's part of what happens too, is like at first, we're in chapter 11, we're trying to make it work, but the train keeps tipping this way and that. Eventually it tumbles over. It's a fire sale. All right, moving on. Here are some alternative strategies to protect yourself from buyer bankruptcies. These aren't legal per se. That's not using the bankruptcy system. It's just using your common sense and doing cost benefit analyses yourself to determine what is going to work for you. Consider not putting all of your eggs in one basket. Consider selling to a variety of buyers so that you are insulated if any one of them goes bankrupt. Now, I say that with this tone of voice because I understand that there's some diminishing returns here. The more buyers you're pursuing, the more transaction costs you're incurring, the more relationships you have to develop, the more shipments you have to make. So maybe it's still not going to work for you, but do consider if you can diversify is to minimize the impact of one buyer's bankruptcy. Same way to say sell to a variety of buyers. Another thing to look at is the extent to which you can focus your relationships on long-term established companies with a good track record for payment and payment on time. You know, some folks did look at the pipeline situation and say, whoa, we got a lot of rapid growth here. We've got someone who is paying higher than the market rate to try to capture market share. I wonder if this is going to work out. I wonder if this is all going to go bad. That's a tough spot for you to be in, to try to assess the viability of a multinational corporation. But again, it is something we got to put on the table that if you're not feeling good about that, maybe a good risk management strategy is to sell to those that you have more trust in, that have earned your trust through their actions. Okay. And again, join with other farmers and farmer associations that are willing to help you develop protections both before and after buyer bankruptcies. So think about working with other entities, and I really didn't put this in there because this is Organic Farmers Association. Harriet and I really thought that this was important to remind farmers of the value of collective action here. Boosting indemnity funds, boosting bond funds, providing more opportunities for farmers to be made whole, giving buyers, giving vendors, sellers help in getting adequate assurance when someone does file for bankruptcy. All of those are actions that are going to be so much more powerful when they're taken in combination with other farmers who are all in the same spot. All right, so I covered a huge list of things. Ooh, I see a question in the chat box. If you file an agricultural lien in a state with a bond fund, will that put you on the secured creditor list? Oftentimes, and states vary. Oftentimes, you can't file an agricultural lien if there is a bond fund. Like the Secretary of State's office literally doesn't have a form or a process for you to create an agricultural lien because the bond fund exists. So usually it's not, you don't get to choose which you want. There's one path and nothing else. But if you aren't sure and you can file an agricultural lien, that's a great step, you know, do it. That's terrific because, you know, if they'll let you do it, it's often a better place to be than a bond fund, especially as compared to an indemnity fund, because bond funds tend to be less well funded.
Rachel, would now be a good time to stop share and we could invite folks to come on the screen and maybe unmute for some questions? It looks like we have another question in the chat, but if folks are more comfortable posing those in real time on video, please feel free to do that. And if you want to stop share, Rachel, I can pop links and stuff in the chat so folks can save those for later.
Sounds good. I'm going to flash you a couple more slides.
Okay.
Farm has 100 plus guides, models, and checklists. Wide variety of farm business law issues. We have advanced courses. You can ask us questions anytime. And I've got your funder credit one more time for the top program. And now it is question time. And I will turn off the screen share and let's visit.
Perfect. And folks, please feel free to come on camera. Hey, Dave, good to see you. Feel free to come on camera if you're comfortable with that. And I did see another question in the chat if you want to take that one.
Yes, how can you have more control over the contract? I will say that this is more of a social question than a legal question. How can you have more control over the contract? When you're working with large national and multinational corporations, you can of course say, I don't like these terms. I want something else. And they'll either negotiate with you or they won't. So, I mean, that's how you do it. But most of the time they won't negotiate. They'll say, you don't want to sell to us, don't, you know? So from a like social and practical perspective, the way you have more control over the contract is you band together with other farmers. You try to build a broader movement towards, look, none of us are going to sell to you unless you do ABC. That's the practical way to have control over it, because each individual farmer just doesn't. I mean, if you're selling to a farmer co-op, a farmer-owned co-op, well, you got control, you know? That's a cooperative. So run for the board, you know, vote when you have a chance to vote. That's the way those systems are designed. But when we're talking national and multinational corporations that are not cooperatives, your control is not selling to them.
Feel free to come off mute if you've got a follow-up, Dave.
And hey, Harriet.
Hey, Harriet.
Again, huge credit to Harriet helping me develop this this presentation.
Hi, well, I was going to write something in the chat, but I'll just ask it. Well, there was a question from a farmer about if the buyer had said they were going to pay the freight and then they bankrupt, and then the freight company is coming after them for the freight. What do you do about that?
Right, right. So that's a very similar situation where if you do something on credit, you know, you drop off the product, engage the shipping company, and they say, look, I promise I'll pay you. That's fine. They'll promise they'll pay you, but you're an unsecured creditor. And if things go south, you're going to have to fall in line with the other unsecured creditors in order to get a piece of whatever pie remains when they are in bankruptcy. So, you know, the single best way to avoid that happening is, of course, don't become a creditor. Get that payment before you engage with the transportation, with the shipper, and then you're covered. It is when you extend value and you're not getting paid, you're not getting the return, the money for that you have more of a problem.
I think it was that the contract for the shipping was between the freight person and the buyer, and they were just picking up. But then when the buyer went bankrupt, the freight company came after the seller, the farmer,
right,
even though they didn't really have any relationship other than they were picking up at the farm.
And legally speaking, there is probably some other relationship that is going on, some form of commitment that was extended in some way through the various transactions that they came to result in that truck being there and loading up that product. So what I'm saying is, it's not a general rule that they get to be like, you will pay for that. You know, there's something in place, you know.
Question. Can you hear me?
Definitely, yes.
Okay. Usually we're doing things on good faith. We talk to a buyer and say, okay, you offer this much. We verbally kind of agree to that, and they send a contract. How do we send one back that's going to be on our terms, because it's usually the buyer's contract that we got to sign and go back on. So how do we avoid that with corrections or changes? Or, I mean, it's just, it's all kind of on good faith, but when it comes down to it, it's all in their favor.
Yeah, definitely. So in the way that things go, you are completely within your rights to print the dang thing out and to sit there with your pen, scratch it off.
Okay.
Say, no, I'm not going to do that.
No.
Write in the margins, like what you're going to do. You have every right to do that. Anybody does when engaging in a transaction with another person. You have every right to take their offer and to modify the offer and say, no, I got a counter offer for you, and you send that back. No, they don't have to accept your counter offer.
But send it back without signing.
You send, okay, well, so technically, you can sign it and send it back, and they have a certain amount of time to say, whoa, notice you scratched a bunch of stuff out, not on board. Now, if they don't notice you scratched a bunch of stuff out and you wrote in other terms, it may hold. It may hold. And I say may because I didn't look that up for the purpose of this presentation. I don't have the facts fresh in my mind. But there is often a certain amount of time that they have, like 10 days. But I cannot commit in this presentation. I didn't look it up for the purposes, and I don't know for certain that those laws would apply to an agricultural sale like this of commodities. This is called the UCC. It's an entire body of law that sometimes applies to agricultural sales and sometimes does not. So it is possible that your sale would fit under the UCC, which may allow a certain amount of time for them to respond and say, I saw you signed it and scratched all this stuff out, and if they don't, it'll hold.
Can you offer to put it in can you request that they pay before?
Absolutely. You can request whatever you want.
You send 100% of what we estimate this, and because I'm sure they won't buy that, but pipeline got really big, really fast, and some of those points you made were very red flagged, but they were trying to grow too fast. I think they wound up selling off to a bunch of other people who wound up getting the brunt of it, I guess, in my opinion.
Right. Yeah.
We are at 2:00. I see one last question in the chat from Steve. Rachel, if you want to take that one, and then we'll wrap.
Yeah. So Steve asks, what is the statement you need to have to minimize clawback? I'll tell you, but I am going to preface this. It's not a statement that you need to have to minimize clawback. It's a defense. It is an argument that you can make, which if you are successful in making that argument, will eliminate clawback. And that statement is that the payment is not preferential. It was conducted in the ordinary course of business. But again, simply dropping that statement on an invoice or in a contract by itself may not be enough. You'll have to prove that through action and according to the details of your state's jurisdictions. So now that I've done the attorney thing and clarified, that's the path you want to go down. Ordinary course of business, non-preferential payment.
Thank you so much, Rachel and Harriet. And thank you for being here, Harriet, for the presentation, and everyone for the good questions and for joining us today. Please check out the Organic Voice magazine and the Organic Farmers Association blog for additional information on this topic. I popped the link to our website in the chat. If you are interested in working on this topic further or on an ongoing basis, please do let us know using that hotline number that Rachel shared. You can also find that on our website or by shooting us an email because we'd love to work with you further. Appreciate your time, and thank you again, Rachel, for sharing your expertise with this group.
Thanks again, folks. It was a good time.
Bye now.
All right, bye.